Hello, my name is Jordan Walker. I'm with Seaver Walker Paget Law Firm. Today, uh, thank you for joining us today to talk about eminent domain and the Big Creek Greenway project. Thank you for joining us. 3:30 p.m. We're going to go ahead and get started. Again, my name is Jordan Walker. I'm with Seaver Walker Paget Law Firm. We are an eminent domain only landowner law firm located in Alpharetta, Georgia. And here we're here today to talk about the Big Creek Greenway project, eminent domain, and what to expect from the process. A little more background about our firm. We are eminent domain only attorneys. This is the only area of law that we practice. And not only do we only do eminent domain, we only help landowners in this scenario. We have never represented the government, GDOT, City of Milton, any entities that can acquire the land. We do not represent them. We are strictly eminent domain. Today, we're going to be talking about eminent domain. We're going to be talking about the project, the Big Creek Greenway project, and we will be talking about what you're entitled to under the law in eminent domain acquisitions. One question we get a lot is, why did you receive a letter? It's because according to our research, your property is likely to be affected by this project. Real quick about the project, the Big Creek Greenway Trail Project is a new trail project. Here's a map right here to your right, depicting where the project will be located. You can see the blue, it's kind of hard to see, will be the new trail that they'll be adding there along the south, and then up towards the north. They'll also be replacing the new trail is the green, and the blue will be replacing existing trails. So regardless, this is going to involve new multi-use paths, and it'll stretch all the way up to ultimately to the Milton border, meet up with the GDOT McInnes Ferry Road interchange project. This is obviously it's a trail project. Trails are fairly common recently. They're a common exercise of eminent domain in Georgia and in elsewhere. And so that is the project. If you have any other questions about that, you can let us know. I should state this is a City of Milton project. The Georgia DOT is assisting in it, but it will be a city. The City of Milton is responsible with acquiring the land for the project. Speaking of land acquisition, we've already talked about it. What is eminent domain? Eminent domain is the power of governmental entities, including the City of Milton and Georgia Department of Transportation, to seize land and set it to a public use. Trails are examples of public uses. The more common traditional method or traditional use of eminent domain is for road projects, but eminent domain can be used for any number of uses, including airports, libraries, governmental buildings, pipelines, power lines. In this instance, obviously it's a trail, but it can be used really for any use as long as that use is dedicated to the public. And so if it is a project that is a public use project, then the entity, in this case, the City of Milton, has the ability to acquire property, basically whether the landowner likes it or not. So they acquire the private land and they set it to a public use. So while they do have this power to take the property, they still have to pay for it. And as a landowner, you are entitled to just compensation for the taking of your property. City of Milton, like any city, has inherent eminent domain authority. They have the inherent ability to take property as a matter of law. The eminent domain acquisition process in Georgia is fairly uniform, regardless of who's acquiring. There are certain requirements that condemners need to follow prior to initiating eminent domain takings. The first step is an appraisal of the property. The property has to be appraised by an appraiser by the City of Milton. And part of that appraisal, they need to perform an inspection of the property and also allow the landowner the opportunity to be present during that inspection of the property. So at some point, they will send you a letter, they should send you a letter notifying you of this appraisal inspection and give you the opportunity to be there if you'd like. After that, you will receive an offer from City of Milton to acquire that portion of the property that they want for the trail. As part of that offer, they are required to provide a meaningful summary of the appraisal that was performed to the landowner. So they do the appraisal, and then they send somebody else back out to issue the offer that's based off that appraisal. And they have to, again, provide a meaningful summary of the appraisal to the landowner. And then if a deal can't be reached, eventually they will need the land one way or the other, so they will file their condemnation petition. And that is officially eminent domain. Condemnation is not, some people, when they hear condemnation, they think of, condemned buildings, blighted buildings, boarded up windows, et cetera, and so forth. That's a different type of condemnation. This type of condemnation is just the exercise of the acquisition of eminent domain, the acquisition of the property for the public use. So they use the courts to acquire the land, and that's eminent domain effectively. When the city of Milton initiates this litigation, they will serve you a copy of the petition, and you will have 30 days to file what is referred to as a notice of appeal. Notice of appeal serves the function of informing the court that you disagree with the amount of compensation that the city of Milton has determined you're entitled to through the appraisal. If you do not file your notice of appeal within 30 days of being served the petition, your case is over and you get what the city determined you were entitled to through its appraisal. So it's very important that you file a notice of appeal if you disagree with the appraisal amount. Ultimately, you are entitled to a jury trial in front of a jury of your peers in the county where the property is located. At that jury trial, you would present evidence on compensation, and the city would also presumably present evidence on compensation. The jury would render a verdict then to what you are entitled to under the law in the form of just compensation for your property. So for partial acquisitions, which this trail project includes strictly partial acquisitions, that is, they're only taking a portion of your property. There are three main keys of compensation that you're entitled to under the law. You're entitled to the value of the property. The value of property is generally determined on a price per acre basis, examining comparable sales in the area to determine underlying proper price per acre. You may be able to employ an argument that your property is actually of a higher and better use or a highest and best use over and above what it's currently being used for. As an example, if you have a residential piece of property that's zoned residentially, used residentially, but all the surrounding properties are commercial and commercial, you're in a commercial development area, yeah, you could argue that your property is in fact or should be valued commercially, as that is the type of property would be sold on the open market. The second component would be remainder damage. Remainder damage refers to any number of factors that can be caused by an acquisition, a partial acquisition of property. And remainder damage specifically refers to any loss in value that the property may sustain because of the acquisition. In acquisitions for trails, for example, for residential properties, proximity to the trail can impact the value of the structure. Some people don't want to be next to trails. They don't want to live next to them. And so if a trail is introduced to your property or you are closer to a trail than you used to be, some would argue that the property has lost value because of that. That would be an example of remainder damage. For commercial properties, examples of remainder damage would more be if the trail interferes with your commercial operation. So you have a parking lot that it's impeding on, and it's reducing your parking, or it's affecting how your business operates, or it's affecting the development ability of your property. Those would be examples of remainder damage. And then finally, business losses. If you can determine that this acquisition is going to destroy your business on the property, you can apply for business losses and get recovery for that in addition to the other items listed. And my final slide is for landowners seeking representation, because a lot of landowners don't have a lot of attorney experience, don't know what it's like to hire an attorney for this type of scenario. These are some common relationship representation agreements between landowners and attorneys in eminent domain cases. The most common would be the contingency fee agreement, where the attorney's fee is contingent on how much more money they get for you than what is offered by the city. In those scenarios, there's no upfront cost. Generally, there's no retainer fee. There's no money exchanged generally until the case is resolved. The attorney takes its fee, and then the landowner gets the rest. And that fee, whatever it is again contingent on how generally contingent on how much more they get than what is offered. Generally, percentages on that, a percentage for a contingency fee on that is around 33%. And then another type of agreement, an hourly billable rate case, that's a more traditional attorney agreement where the attorney bills for their time. So anything they do, they bill back to the client at their hourly rate. So if they write an email, attend a hearing, draft a pleading, respond, file the notice of appeal, have a conversation with you, that's all billed on the amount of time spent on that specific task at the attorney's billable rate. Oftentimes, that type of agreement comes with a retainer, which is an upfront money deposit made by the landowner, the client, that the attorney bills against until it runs out. If the retainer, say for example, is $5,000, and the attorney bills over $5,000, the attorney may ask for a retainer replenishment, or they might just continue to bill and send you invoices on the agreed upon time period, usually monthly. That is the end of my presentation. If you have any questions, feel free to contact me. You can send me emails at jordan@swplegal.com. You can also call me at 470-869-1383. Thank you for stopping by, and good luck with your case.